Crime is wickedness. Crime is greed. Crime destroys families. Crime divides nations.
Evidence from the court because there's new evidence now that's being presented. That's the court pieces.
Mr. Nisi?
As it is the court, my lord, it will be recalled that I was in the process of cross-examining Mr. House when there was an issue regarding the content of the record, which has since been clarified. I therefore need to proceed from there. But beyond that, there's also new information which has just surfaced. That is got to do with accused number 3, my client. There's also a very mysterious number that is now resurfaced in terms of the document that has been sent overnight. There's also a new number. And all along the state was asserting that accused number 3 is not affected by these cell phone records, but all of a sudden there's a new number. I haven't consulted that. I don't know where the number comes from or applied for that number. How does it really affect him? How does it really affect him so far as this case is concerned? Those are all the concerns that I have, that I also need to study these documents, these voluminous documents. But if the court can just look at these voluminous documents, and I'll also have to study them and go and consult with Mr. Nure in order to get proper instructions. Because I don't want a position or a situation at the end of it all where the state would want to come and argue that accused persons are changing their versions, are chopping and changing their version as the case progresses, because this is out of their own making. Thank you.
Yes, Mr. Omalo.
My lord, I wish to confirm that I've also received additional information this morning, which was not supplied to me on Tuesday. On top of that, my lord, on the affidavit of Lieutenant Kenneth Bowes, he also says that when he analyzed the numbers, there is also SMSs, communication through SMSs that I've requested from the state to provide me in order to further consult with my client. Thank you.
So you haven't got those SMSs?
Yes, I haven't received those SMSs, my lord. Thank you.
Hello, ladies and gentlemen. You are welcome to the channel. The defense is very frustrated by how the state is going on with the trial. Hence, they call it the trial by ambush. Because the evidence comes in drips and drabs, and they have to read the new evidence provided to them. They have to consult with their clients and have to come back to represent them in court. But I think the state, they are within their right to bring in new evidence as the court progresses, as the trial progresses, because at the end of the day, they are the ones who has to prove beyond reasonable doubt that they have the right man, the right accused on the dock. I don't know what you think. Tell me in the comment section what you think about that. This back and forth takes us back to the investigation of the case. One would think that all the evidence should be collected and then be brought before the prosecution, before the trial commences. Now we see new evidence being brought in meanwhile the trial is in progress. That is why now the defense feel that this trial is by ambush. They are given new documents now, and they are expected to defend their clients now. Because the judge also is putting a lot of pressure on them. He sometimes displays some level of impatience towards the defense. Let me go back to the investigation of this case. It's not very common to find an accused person who can just plead guilty of an offense, right? As you are investigating, obviously, you know that the accused is going to deny the accusations labeled against him. He's not going to plead guilty of an offense. So you have to make sure that you gather all the necessary information or evidence that will place the accused person at the scene of crime at that time before you even approach the prosecution. Now, In Senzo's case, we see the investigation still being carried out even when the trial is in progress. The investigator still had to make a request for bank statements and so on. We hear the defense complaining about the state bringing in the accused person's information of 2018, 2020, and so on. Let us not forget that the state is trying very hard to prove beyond reasonable doubt that they have the right accused persons on the dock. Because remember, at first, the guys said that they don't know each other. And then the cell phone records showed that there was a conversation among some of them. The cell phones also placed them at certain places during that time of the crime committed and so on. So the state will continue to go back and forth to prove that they have the right people. The defense is panicking because of the judge. The judge is very impatient with the defense and want to rush them. That is why they blame the state. But the state is within their right to go back and forth, because at the end of the day, they want to prove beyond reasonable doubt that they have the right accused persons before the court. Let me know what you think on the comment section, guys. Thank you for watching. Danko.
The incomplete statements of Colonel Genenda, my lord. We were told that they will be supplied later in the day, which was on Tuesday, on the 30th of April, my lord. And those pages, they never came, my lord. Out of the bundle that was supplied to us on the 30th of April, my lord, there was a bank records for accused number 5 from Absa Bank. I managed to secure a consultation in prison, my lord, even if it was not legal visit was not allowed. However, the head of the prison allowed me to consult. I consulted on that document, which is Absa records, which was made available to me on the 30th. This morning, I received another bundle of documents from the state, of which I have not been able to read them. I can see also the email was sent last night at 2300 hours, of which I was not told not to sleep and wait for this email. Unfortunately, I couldn't read it overnight. As a result, my lord, I would like to place it on record that this is a trial by ambush, my lord. Yesterday, I had all the day to consult with my client on all the documents that the state is preparing or anticipating to use. However, the documents were not supplied to me, especially the affidavits which were marked by my learned friend, Mr. Baloy, that there are pages that are missing. And my lord, what is very bad in this trial is that the state is dishonest with this court. The state is not telling the truth in this court, that they need time to investigate and to compile all the necessary records that are supposed to be supplied to the defense, so that we can be able to consult properly and then be able to run with this trial. Now, Mr. Host,
I strongly object to the language employed by my learned friend, say that we are dishonest. We are officers of this court, we will never be dishonest. No, English is not our language, but I suppose that's not really what, or I want to believe that's not what my learned friend is implying, but we will never be dishonest. I'll say this slowly so that I'll be understood, to say, during the inception of this trial, even if I was not there, but I followed the records, none of these accused persons tendered a plea explanation in terms of Section 115. No one. The only state, it's a fishing expedition by the state now to say they listened to the version that was put by my colleague Mr. Ramsepidi in one of the witnesses to say accused number 1 was not in Gauteng on the day Senzo was killed. Now the state wants to focus on that. They now deviate from the elements that they need to prove on what happened in 2014. If the state was confident enough that they have something to say before this court, they should have led evidence. I'm not dictating, but they should have led evidence in relation to, for instance, my lord, let me just put it into practical perspective on what was delivered or was said before this court. Mboto read the affidavit of accused number 1. Rapadu read the confession of accused number 2. It dealt with the communication where Kelly asked, where are you? Those are records that are relevant. I'm in possession of the 205s for Kelly Kuman. And the state, I'm going to show the state that there was no such a communication. That is direct evidence. I'm not sucking a thumb to say I'm looking for the number for Ntuli, for Mapisa, for whoever. I've got the records for Kelly Kuman on the date of when Senzo was killed. They're busy with 2018, 2021. We are not really interested. That's not our defense. The main defense during Section 106 was that it's a bad denial. They denied having killed Senzo. So now they want to create their own defense because of what my colleague Ramsipidi said. Accused number 1 was not there. They're busy now. That's why one will be tempted to say they are cooking. They are manufacturing day in, day out. So that it can fit what the state wants to do. Because I can tell this court now, they don't have a case. I'm not arguing the case, but I don't see the purpose of this witness to be here. Number 2, this disclosure, what time do we have to go through? Because if you consult with the client, sentence by sentence, transaction by transaction, is this fair? Is it fair trial to this accused? Moreover, our defense, we blatantly denied, vehemently denied the involvement of this accused in the killing of Senzo Meyiwa. I even put it on my cross-examination or in one of the investigating office. And I still have to prove that that evidence in this court. Now they're busy fitting us with 2018, 2020, 2021. We don't even have time to consult. This is pure ambush.
Okay, thank you.
My lord, may I say this for the last time? When I get into this trial, it was trial within a trial. The court made it an exception that discovery can be made during a trial within a trial, not in a main trial. Now we're getting everything here. Thank you, my lord.
Okay.